adorably to their cat or whatever they're doing.
Only if it's not your toddler.
Well, I mean, isn't the reason that the problem isn't that it's your toddler because there's implied consent there, and that might be the case in a relationship, certainly without any testimony that there wasn't any.
Well, but there's a ton of testimony that she not only did not consent to this picture be taken, but she never allowed him to take any pictures of her in the nude.
She'd never testified that she told him not to, or that they, she said that we hadn't done that before.
She said she did not consent to this picture being taken.
She did, yes, and the implication is that without explicit consent, every picture of a nude or partially nude person represents a potential criminal offense, and that's why we're arguing that the statute's reach is vague and overbroad.
I just have one more question. This constitutional issue was not preserved at trial, as you note, and our case law cautions that we don't review constitutional issues raised for the first time on appeal unless the record is fully developed, which begs the question, how is the record fully developed here?
I'm not sure what else would be required to fully develop the record.
Well, for example, it wasn't part of the defense in any way. It seems to me that the defense was that the conduct here, that the Commonwealth didn't satisfy its burden. There was no claim, for example, that the conduct was ambiguous or the conduct was legal or anything to that effect, which would have given us a more fully developed record. Don't you agree?
Yes, I do agree. That would have been preferable. But as I discussed in my reply brief, just because it's not preserved at trial doesn't mean you can never argue constitutionality. It just means that it's measured by this typical standard of a substantial risk of a miscarriage of justice.
Thank you, Ms. Sherman.
Thank you.
Good morning, and may it please the court, Catherine Sherman on behalf of the Commonwealth. I'm joined on the live stream by Assistant District Attorney Kevin Bergen and the victim on this case. Beginning where counsel's argument left off with the claim of unconstitutionality here. As the court has alluded, the big picture question here is that there is no First Amendment right to photograph a nude person without their consent. As the panel has made clear, there is no record in the lower court fleshing out this issue. And related to this issue, which has also been raised in argument, is the intent of the defendant. As has been made clear by the questions and the argument thus far, his intent is clear. He took this photograph of the partially nude victim when she was asleep, or as the trial judge characterized, unconscious. She had never consented to nude photography, did not consent to this photograph, and she did not know it existed.
Can you address the question I asked Attorney Rose, which is, can conduct that occurred after the crime, in this case 3 years after the crime, be considered as a factor vis-a-vis the intent element?
Yes, I believe it can be considered. As was mentioned, I think it ties into consciousness of guilt, that he is revealing his intent and the reasons why he kept it secret for this time. He took the photograph secretly and did not show her the photograph before them because it was his intent to hide it from her, hide that activity. However, related to that issue, the text on the nude photograph isn't his only indication of his intent, and his intent at the time of sending the photograph is really not the question before the jury. It's his intent at the time of taking the photograph, for which the evidence is abundant, and certainly taken in the light most favorable to the Commonwealth, and all of the reasonable inferences therefrom proves that he had the intent to take this photograph in secret and to hide that activity, and that he was willfully taking a photograph of a partially nude person, which is an important other element related to his intent.
Okay, counsel, say he had taken the photograph in secret with the intent to make a birthday present of it. He thinks the photograph is beautiful, wants to make an art shot, but he and the victim break up before that happens. Same result or not?
Yes, that still meets the elements of the statute. The intent to take the photograph secretly is only one part. It's part and parcel with the fact that the person who was being so photographed had a reasonable expectation of privacy and did not consent to that photography.
Well, I mean, don't we need to parse the reasonable expectation of privacy? Because surely she did not have a reasonable expectation of privacy regarding his viewing her in the room. Aren't you saying that the reasonable expectation of privacy here was in not being photographed and having what he could see with his eyes memorialized in pixels?
Yes, that's correct. That's the distinction.
But even if he intended to show it to her, you think that's still enough intent under the statute to make out a crime?
I think that the only difficulty with that hypothetical is how it would be revealed and become known to the victim. I suppose if in your hypothetical he took the photograph and deleted it and nothing ever came of it, it would not rise to criminal conduct because it would not be discovered. Unlike here, where the photograph was kept, retained, and as the court has said, used as leverage.
But doesn't the intent have to be present at the time the photograph was taken?
Yes, and
so how is whether or not how it came out later relevant?
I suppose coming back to your hypothetical, the intent that your hypothetical photographer has is to not hide that conduct and hide that photograph, if I'm understanding the hypothetical. That photographer intends to show the photograph and to share it with the victim, unlike here, where he violated her explicit lack of consent to nude photography. He took the photograph while she was asleep and could not possibly be aware that he was so taking it, and did never show it to her.
Yeah, but it certainly, if he had taken it because he thought it was an arty shot and then showed it to her the next morning, he couldn't be prosecuted, could he?
Well, that's not completely dissimilar from the facts in Bark, where the sleeping victim has her genitalia photographed and it's shown to her in short order by the photographer, and that was a conviction under this statute. If there are no further questions about the elements and the sufficiency of the evidence, I'll turn to the issue of authentication. What's the most important aspect of the photograph in this case is that the defendant was not charged with disseminating the photograph. He was charged with taking the photograph. And though the Commonwealth proved by a preponderance of evidence that he had sent phone text messages, Instagram messages, and the photograph to the victim by exceeding the confirming circumstances standard, that was not necessary for the photograph to be authenticated and properly put before the jury.
That may be true of the photograph, but why isn't your sister right that it isn't necessarily true of the text? I mean, perhaps there was enough to authenticate the text. Well, I mean, the text superimposed on the photograph, because that seems to be an essential part of the Commonwealth's proof of his intent.
And is your question specifically related to the superimposed text or the phone and Instagram text?
The superimposed
text. The superimposed text is properly authenticated because of its relationship to and the context related to the other properly authenticated messages. These three types of messages all work together to confirm that it was the defendant who authored them and sent them. Beginning with the text messages, phone text messages that lay the foundation, that the victim testified to the fact that she had paid for that phone number, that it belonged to the defendant. They had communicated on it for years. And the messages within those text messages communications are unique to the relationship between the victim and the defendant. It references her birthday. It references her not responding to the messages because she's out of the country, as she testified to, and did not respond to messages. And then And that then relates to the Instagram textual text messages sent through that platform that refer to the text messages, screenshot the text messages to them, refer to the fact that she's not responding to him, and finally culminate in the sending of the photograph with the superimposed text that again references back to all of the other messages and the communication that he's been sending to her. The authentication of all of those work together and by more than a preponderance of the evidence prove that the defendant authored and sent them to the victim. If there are no further questions, I will rest on my brief.
Seeing none, thank you. Thank you both. We'll take this under.
All right, we are now live and recording.
Good morning. Welcome to the appeals court. I am Justice Meade. With me today are Justices Milkey and Neyman will be the panel on your case. With that, the case number is 2000 P596 Commonwealth versus Miles. Mr. Harper Nixon.
Thank you, and good morning. May it please the court. Matthew Harper Nixon on behalf of Arthur Miles. I think I should first address the court's order from yesterday regarding the impact of the 2011 appellate decision, published decision. First of all, I have to apologize to the court for missing this issue. I've been litigating the case for over a year and a half now. It never somehow...
You're not the first one to have missed it.
Apparently not, and that makes me feel slightly better, but it was my case, and I apologize to the court for the confusion. That was inappropriate.
We appreciate that. I mean, it dawned on me when I picked this up. I was curious how a panel of this court reversed his ABPO on Melendez-Diaz grounds.
It's a fair point.
Sore thumb there.
No, to be sure. And all I can respond is that I think it will, and frankly, I've only had a day to address this, so I don't have an entirely good answer for the court as to how to go forward. I will acknowledge that.
Why is there a case at all anymore?
Well, that's the interesting question, Justice Meade. If the court finds that, in fact, that conviction was never overturned, then I would agree that the appeal is moot because there was nothing for justice. It said
so. The other thing is apparently no one, neither you two or anyone else in the trial court ever read the 128 in this case.
Well, I frankly did skim over it, but I will acknowledge that I missed that footnote to be sure. And my best response to that is that, as you say, the trial court proceeded as though this case was all three charges to be resolved. The docket indicates.
Why isn't so? He pleads guilty to a charge he's already been convicted of. Why isn't that a complete nullity?
It would be a nullity if that is ultimately what the court finds happened. And so my only response in terms of, again, a day's worth of research is that the court could conceivably treat this, and this is not a perfect analogy, I have to concede, as where a case where there's some charges are overturned on appeal and others are not, and the court is allowed in its discretion to restructure sentencing. Granted, that's sentencing as opposed to conviction, so it's not the same situation. I mean,
it might have made this more interesting if he got a larger sentence than he did after conviction, but he did not, and everything else has been vacated. And the relief you're seeking is for the withdrawal of his guilty plea. Even if we granted that relief, which I doubt we will, but even if we did, he still stands convicted of assault and battery on a police officer.
In terms of the allowance of, even if you were to grant the relief as to the ABPO charge?
The relief you request in this case is twofold. Let him withdraw his plea to ABPO, or the alternative to give you an evidentiary hearing. Is that correct?
Correct. That's right. Yeah. Yes.
So if we gave you either of those, it wouldn't make any difference. He'd still stand convicted of ABPO.
Well, certainly you would have to have an open charge again if you allow the
He'd
withdrawal.
Have to what?
Oh, I'm sorry, because you're saying there's no plea in the first place. I mean,
the plea is a nullity.
Again, if that is how the court sees the case, then I don't have much of a response to that.
Well, please tell me how else to see it.
Your Honor, I don't have a response at the moment beyond that. Everyone, 6 attorneys, two Superior Court judges, the clerk's office have all treated this as though it were a circumstance in which the case was going forward. Maybe this was all a huge confusion. The rescript references.
It certainly was.
The rescript references vacating all the verdicts. The entry from the clerk's office does indicate that.
In the text of the 128, it says, and I quote, we conclude the evidence was sufficient, but screensaver. But the erroneous omission of the certificates of analysis require reversal of the drug convictions.
Mhm.
And then footnote 3 says he does not appeal his assault and battery and police officer conviction. Now, you're a very experienced attorney, Mr. Harper Nixon. You know that when you don't appeal something after 30 days, it becomes final.
That is true. Your Honor, I have to acknowledge that if that is how the court views the case, and I'm afraid I don't at the moment have much more to offer beyond this analogy to where you're restructuring sentences. Again, it's not a perfect analogy. It's best I come up with in 23 some odd hours. But certainly the appeal will be moot. I can't argue with that. And so if that's how the court views the case, then certainly I think it would be mooted out. I'm happy to address the merits if the court would like to hear it, but I'll leave that up to the panel.
I just have one question, so it's perhaps in the form of a hypothetical, but as I understand your argument, it's that had the defendant known that the drug charges were tainted, he never would have accepted a 3-year probation plea deal on the ABPO, correct?
Essentially, that's right, yes.
Why does that have to fall under this rubric of indivisibility? I mean, it seems to me that in such situations, your argument really is his plea was not knowing and intelligent. Why do we throw this into the box of indivisibility? I'm not even sure where this came from and why it's necessary.
I do think it's a combination argument, to be sure, Justice Neyman. I think the indivisibility issue really gets to the question of how to address cases where there has been some error. It's not just drug cases. It's any case where there's an error that infects some aspect of the plea. Frankly, indivisibility was how I looked at it in terms of my analysis of it. It could be that there's more of a traditional involuntariness claim to be made there. But I think from purposes of the analysis, to some extent, it doesn't necessarily change how you look at it, because the question is, were he not facing those drug charges, would he have pleaded guilty to that particular charge? And that's going to be very fact specific, but I think the indivisibility is one aspect or one way to look at that. But to be sure, it could well come into the rubric of traditional involuntariness as well.
Thank you.
Do you have any questions, Justice Milkey?
Thank you.
Thank you, Mr. Harper Nixon. Mr. Shorey.
Good morning, Your Honors. May it please the court. I'll start by adding my apology to missing this issue. I did read the 128. I don't know if that makes it worse or better that I didn't pick up on the issue, but beyond that, I don't have much to add given Attorney Harper Nixon's concession on the point, unless the court has specific questions.
Yeah, usually when the government wins, they don't fight hard to try to snatch defeat from the jaws of victory, right?
That's typically the case, Your Honor.
And I know you weren't. Although we don't have the transcript, I'm pretty sure you were not the ADA in front of Justice Ball in the Superior Court.
That's correct.
Yeah,
correct.
And nor in front of I don't want to mispronounce the judge's name, Elagizian.
Correct.
Yeah. I think in the future, you need to pay attention to the details of the cases that are in front of you. An enormous amount of judicial resources was wasted in this case, in addition to your own time. Any questions? All right, thank you.
All right, we are now live and recording.
Good morning, Your Honors. Lois.
Wait a minute. Welcome to the Appeals Court. I am Justice Meade. With me today is Justice Milkey and Justice Neyman. We'll be the panel on your case. And that case is 2018 P 1502 Commonwealth versus a juvenile. I want you to know that we've read everything. And if we have any disruption for electronic reasons or otherwise, we'll try to reestablish contact with you as soon as possible. No one will be deprived of any time that they're entitled to. You may notice occasionally we look off to the side. It's for the most part, we were looking at the notes from our cases and we are paying attention. Okay, go ahead, Ms. Martin.
Good morning, Lois Martin here on behalf of my former juvenile client. I will call him client as hopefully as best as possible. According to LL versus Commonwealth, and which was a 2014 case, and Ernest E., which was just this past November, the standard of review for these types of cases is the trial court can relieve the offender if he does not pose a risk of reoffense or a danger to the public. And in the LL case, the court changed the standard for deciding whether a judge abused their discretion or not, which is when a judge made a clear error of judgment in weighing the factors relevant to the decision, such that the decision falls outside the range of reasonable alternatives.
Counsel, could we start with the issue of jurisdiction?
Okay.
In your reply brief, you seem to acknowledge that this case is not properly before us, but you ask us to address the merits anyway. The SJC is a court of that has general superintendent's powers, allowing it to address issues even when they don't have jurisdiction. What allows us to do that?
Well, I would just say that the cases before you, that the Commonwealth I admit that it was an error. That I filed a motion to relieve him of certain conditions of probation. So I didn't think of it as a 211-3 case. I thought of it as an appeal case automatically. The fact that the judge did allow the GPS with taking off the GPS, but still left the SORB issue did not unfortunately catch my attention to revise it to a different, to do a 211-3. However, once it was in the appeals court, and the Commonwealth was responding, they did not object. They did not move to dismiss. They responded to my arguments. They fully briefed their case, my case.
One of the responses is that we don't have jurisdiction.
Well, I would suggest that you must have jurisdiction because after I received the Commonwealth's brief, I contacted the Supreme Judicial Court Single Justice Office to find out how I rectify this. And they advised—
If this isn't in the record, Ms. Martin, you need to keep it to yourself.
Okay, well, I'm just explaining about the jurisdiction. I was advised that I needed to leave it in the appeals court. That it was, so as far as I know, you have jurisdiction.
Well, I think it's Roberto R. says we do not have jurisdiction. You should have brought a 211-3. And the case you rely on it being fully briefed in the appeals courts. That's the sort of thing we can exercise our discretion in when a matter is moot, not when we lack jurisdiction.
Well, I would suggest in the interest of judicial efficiency that you consider this case, because if you dismiss it or you don't rule on it, then I just have to start all over in the 211-3. And based on the Orion case that was just denied by the SJC because they filed their 211-3, I guess, like 10 months later.
Well, you can, as the Commonwealth points out, rather helpful to you, she outlines how you can go about making this challenge properly. And that begins with the Sex Offender Registry Board asking to be reclassified. And if you're unsuccessful there, then you can go to the Superior Court under Rule 30A and do it in that manner properly.
But the standard at the SORB is different than the standard on LL versus Commonwealth, and I would suggest that would not assist my client.
Can if you want to turn to the merits, I mean, you are not just asking your client to be relieved from a probation condition. You're asking him more generally to be relieved from his independent obligations to register with SORB. Doesn't that relief have to come through a motion file pursuant to Chapter 6, Section 178E, small f?
That's what I was just going to read you. He must.
Okay, but can you answer my question first?
That's the statute that impacts whether someone is relieved or not. But
okay, but isn't that a very limited process in two senses? One, procedurally, that has to come within 14 days of the sentence, which at this point was years ago. And then secondly, doesn't the statute say the judge cannot give such relief where there's been a conviction of a sexually violent offense? So how did, on either of those independent grounds, the lateness of this application and the violent nature of the offense, how is this even properly before the trial judge?
And the reason that it was filed years later was because until the Commonwealth versus Samuel case, that one was not allowed to, that was when they decided that a separate decision must be made with regard to whether someone has to register with SORB or not.
And you think that is true even where we're dealing with a violent sexual offense?
I do. Judge Erskine, who said that she was very familiar with the SORB issues, allowed us to have hearings on this motion based on the Commonwealth versus Samuel, which I agree is years later, but she acknowledged that she had not separately determined that issue at the time of his original sentencing in 2010. And so that's why she allowed us to have that hearing.
Well, let me ask you directly. Why doesn't the statute preclude the judge from offering such relief, whereas here the offense at issue involves sexual violence?
Because he was tried, he wasn't tried as an adult, he was tried as he was charged as a youthful offender on this. And the youthful offender, as you all know, considers them, even though they're in some ways treated as an adult, they're still considered juveniles. The legislature under 1953 said that they are still juveniles. They must be considered given aid, encouragement, and guidance. And that's the youthful offender. So that even if he was charged with what would obviously was a very serious offense, he was supposed to be treated as a child, as a juvenile. And that is why she allowed the hearing. And she then, it went on for quite a while. It wasn't like it was, a one-day operation. There were 3 days of hearings, and she issued a lengthy 25 pages of findings. I would suggest the court felt she had the jurisdiction to do this. If I might continue.
Go ahead.
Okay. The issue is that she was supposed to, under 178 EF, she was supposed to assess the risk of his reoffense based on the circumstances of the offense in conjunction with the offender's criminal history. His only adult criminal history is a charge that was null-prossed, and I think that was in somewhat documented in some fashion to reflect that it really, was not an honest charge. And the fact that the prosecution dismissed it and null-prossed it, I think reflects that. And part of the exhibits is a letter from his trial counsel saying that the charge, he felt the Commonwealth did not believe the alleged victim. The problem with the reason that we're appealing this is that it does not appear that the Judge Erskine she seemed overly focused on the offense versus his criminal history. The fact that he had a criminal history, almost all of it was juvenile, as reflected in the record over and over again. She acknowledged it, even all the experts, both experts acknowledged he had a horrendous dysfunctional family life, very traumatized, in and out of hospitals, in and out of, sent back to his mother, who had mental health issues and drug addictions, and clearly was very psychotic. It appeared to always be picking on her son. She never took his side, it appears. It was always, even in the record that is presented, there's on pages 22 and 23 of the exhibits that were presented, there's his probation officer in Lawrence saying that he reading over the documents, did not believe that all of what his mother had been saying about this young man. And the problem is that children always want their parents to, they want support and encouragement from their parents, so that he kept being sent back there, being disappointed, being put in situations that caused him to develop all these things that happened to him, including, you know, one of the things that Judge Erskine points out is all these juvenile charges, but there's no documentation to prove what they were all dismissed ultimately. There's nothing that was presented by anybody, by the Commonwealth at any stage, that proves whether any of those charges ever were real, whether they were just said things by his mother or by someone else. Nothing ever was presented to reflect that they were accurate.
Did you want to say something about the impoundment issue too? Because it doesn't appear you're properly before the panel for that either. You don't address this in your reply brief. You did the 211.3 in the first issue, but.
Well, the impoundment issue is something that, you know, I found the first day of the court hearing, the judge asked.
I'm asking a procedural question, Mrs. Martin. Under Rule 12 of the Uniform Rules of Impoundment, a denied motion to impound in the trial court must go before a single justice in the first instance, not a panel.
I dispute. The judge brought up all the impoundment rules, but I argued that the
no, I'm talking about your appeal here, ma'am. It should have gone to a single justice of the appeals court.
Well, again, that's the problem of the case was already here. How can I go to the single justice with half the case when half the case was already in the appeals court?
Well, that returns the original.
At a certain point, I filed a motion to consolidate these two parts, and they were consolidated. So, by your court. As the clerks in our appeals court are neither advocates for one side or the other. No, I recognize that, but the problem is that there was an error at the beginning. The case is there. Why would the SJC, they wouldn't want, I mean, the single justice would not just want to rule on one part of a case. It just didn't make sense. It
changes the standard of review for one. Well, go ahead. Tell us why, in your remaining 2 minutes, why it should have been impounded.
Well, I think it should have been impounded because part of the case was delinquent juvenile charge of assault and battery, and part of the case was, of course, the assault with intent to rape, the youthful offender charge. If it had just been the assault and battery, it would have been impounded automatically because all juvenile cases
But
are
you,
impounded.
correct me if I'm wrong, you asked for all the records, not just the juvenile records, to be impounded, right?
Well, all of the records of the case. As I state in my, I think it's in my brief, if not the reply brief, the documents about SORB are automatically impounded. The juvenile cases like DCF papers would be impounded if there were any. And I might just point out that the judge repeatedly went into his juvenile history, but there is no DCF records in the SORB. If you look at their risk factors, they're not looking for juvenile things. Only the judge was obsessed with the juvenile history. But in any event, if you can't pull apart documents, in other words, if you went through the court findings with regard to offender, his original sentence, you can't pull out paragraphs. You'd be redacting hundreds of pages, portions, and it would mean nothing. So it made no sense to me to try and separate the cases. And I argued that in my brief. So, well. I guess the bottom line in my last 11 seconds, I would just say that she treated his juvenile history and record as though he had been an adult. But the legislature and the appellate courts treated him as a juvenile. And
okay, I think we understand. Thank you. Your time is up. Ms. Salois.
Good morning, Your Honors. Abigail Salois on behalf of the Commonwealth. This court should affirm the juvenile court's decisions regarding the defendant's.
We should affirm, or we should say we lack jurisdiction, which are two very different things.
Yes, of course. So I wasn't going to go too deeply into the jurisdiction claims, only because since the court has scheduled this argument and has not dismissed the case from your docket, I wasn't going to spend too much time on that. But of course, I do argue right off the bat that neither of his claims were brought properly before this court. And of course, I'd be glad to answer any questions that Your Honors have on that topic.
Well, that begs the question. Assume
Sure.
we agree that we don't have jurisdiction.
Yes.
What is the appropriate remedy? Or what is the necessary remedy if we don't have jurisdiction?
The necessary remedy would be to dismiss the case and order the defendant to file a petition under 211(3) to a single justice of the SJC on the registry issue, and to separately file a petition to the single justice of this court on the impoundment issue. That would be the proper remedy. I just, I'm prepared to address the merits of the case if Your Honors would like me to, only because, if you're inclined to decide those issues for the purposes of judicial economy, and because we're here having this and the cases have been fully briefed. But I will take your lead on whether you'd like me to do that, or if you would.
I'm perplexed by a concession that the Commonwealth made in its brief, and that is that in light of Samuel S., the motion was properly in front of the juvenile judge.
Yes.
Now, in Samuel S., there had been a timely motion or petition filed pursuant to Chapter 6, Section 178EF. And the issue was, did the judge properly resolve that petition?
Mm-hmm.
Isn't that very different from what happened here, which was there was a plea agreement and no effort pursuant to the statute to get the guy relieved of his obligations to file? So how does Samuel S. say anything about whether years after the fact, the youthful offender can go back to the juvenile judge and say, oh, I want another chance to file such a petition?
My understanding of why that was properly before Judge Erskine was because in Samuel S., they talk about how, or the court rather talks about how it needs to be an individualized approach, considering particular factors to decide whether or not a juvenile is, or a youthful offender rather, is required to register as a sex offender. So it's not automatic just because of the nature of the offense that he pled guilty to or was adjudicated of. But here, the defendant seems to argue that Judge Erskine's registry decision was an abuse of discretion because she focused so much on the seriousness of the offense and the impact on the victim. And as my sister mentioned, his record. However, the judge's detailed and thoughtful findings that she made, which are at page 54 of the record appendix, I believe, show that she carefully weighed the relevant factors to that decision, including the youth's personal and mental health history, his juvenile delinquency record, the serious and violent nature of the offense, the SORB factors, as well as both of the experts' testimony. So yes, she did consider the seriousness of the offense and the offense.
Counsel, can we just, before we leave the issue of whether or not the motion was even properly before Judge Erskine, are you familiar with the case John Doe number 147721 versus SORB, which is 82 Mass. Ap. 38? It's a case that neither party cited in their briefs. but it talks about the limited role of a judge under Section 178EF. If you're not familiar with it, just say so.
I'm sorry. Yes, I'm not familiar. I was just writing down the site. I'm sorry, Your Honor.
Okay.
No, I'm not familiar with that case, unfortunately. It seems as though, you know, Judge Erskine was following more of the case law, the juvenile court case law, like Ronald R. and Samuel S., and just trying to give this young man an individualized approach. And he did fully consider, you know, certainly Judge Erskine, as well as the Commonwealth, is not doesn't take a deaf ear to the incredibly traumatic childhood that this young man had, and certainly exercise compassion in taking that into consideration in his decision to register.
Just a factual detail, I take it the Commonwealth did not appeal the dropping of the GPS condition?
No, it did not.
Could we actually turn to the impoundment issue?
Absolutely.
As you know, it's uncontested. The youth was charged both as a youthful offender and as a juvenile. Which set of impoundment rules therefore apply?
So the lead case here would be Doe versus Attorney General, and that's a SJC case from 1997. And it says that once a juvenile is treated as a youthful offender, he is no longer given the protections or privileges of a delinquent child. So that tells us that, so also by statute, because the youthful offender statute says that proceedings are open to the public, just like adult criminal court records. And that brings up—
Was the youth in that case charged in the same case as both a juvenile and a youthful offender? Or was it just that he was charged as a youthful offender?
Sorry, can you ask the question again? I think I'm not understanding it.
I'm going to read Doe versus Attorney General, but if you know,
Okay.
Was the youth at issue there charged in the same case as both a youthful offender and a juvenile? Or is the passage you just referred to just simply saying that when you're charged as a youthful offender, these other protections don't apply?
I don't have that information, and I don't want to say the wrong thing, certainly. I will say, though, that, you know, looking at the uniform rules of impoundment, which govern here, unless something is impounded by statute, with the youthful offender cases are not, then those are the rules that govern. And here, the defendant had the burden to show good cause and to make a specific request. So as far as separating out the delinquency piece, he certainly could have, and as my sister suggested, it may have been tedious, but he certainly could have suggested that all of the delinquency material or file be redacted.
Even as a conceptual matter, I'm having a hard time figuring out how that would be done, given the nature of the charges here. His attack of her was all wrapped up in the assault with the intent to rape. He is, you know, hitting her head against the wall, and as he's trying to rape her. I don't see how you would separate out, you know, which documents or testimony referred to one versus the other. Isn't it really more of a question of, do you apply the youthful offender rules or do you apply the juvenile rules, which I would add, I believe is impounded by statute, correct?
The juvenile stuff is impounded by statute, yes.
So if the juvenile impoundment rules apply by statute, is this even a Rule 12 case?
I think it is because of the youthful offender case. And if you look at, you know, Massachusetts common law has long recognized this presumption favoring the public access to case records. You know, it doesn't, there's no case law that says a juvenile gets the benefit of the doubt when it comes to public access to cases, and going more towards the good cause standard. So the defendant has the burden here to show good cause and make a specific request. So in my brief, I used as an example, because I couldn't find a definition for good cause, but the Silva case gave a good example, and that was impoundment of juror identifying information, so the name and address of a particular juror, and that was in a gang-related murder case with justified juror safety concerns. Here, the defendant has asked to impound the entire case, so it wasn't specific or narrowly tailored, and it was in an effort to move forward of his goal in becoming a good citizen and having a normal life, which is incredibly broad, and I don't really see a difference between that and the proscribed reason, which was, public embarrassment or the like.
Okay, but if your sister were correct, passing over the jurisdictional issue, if your sister were correct that the juvenile rules on impoundment apply here, then he wouldn't have to show good cause, right?
That's correct. I just don't agree with that argument, and I don't think it's legally correct. I mean, my sister has indicated that she incorrectly assumed that the entire case was impounded because hearings had been closed to the public, some of the hearings, I might add. And counsel's error doesn't mean that Judge Erskine's denial of the defendant's motion to impound was an abuse of discretion. Certainly the closure of a courtroom is not the same as impoundment.
But if your sister is correct that by statute this should have been impounded, then the judge didn't have discretion, did she?
Correct. That would be correct if that were true. Yeah. I don't really have too much else. If we're looking at the merits of the case, I would just argue that Judge Erskine's decisions, both with regard to the registry requirement and with regard to impoundment, did not fall outside of the range of reasonable alternatives. And going back to the jurisdiction requirement, as I briefed, I would ask that this court dismiss the case and order that the defendant must file a petition to the single justice in the SJC regarding the registry requirement and file a petition.
Why wouldn't that be too late at this point?
I don't believe, so I know that under 211.3, there's not the, oh, you're talking about the impoundment because of the 30-day requirement?
Well, actually, I was thinking of both.
Okay. Well, no, it's a good question as to the impoundment because I know under 231.118, I believe there's a 30-day time limit. So she probably would be time barred from filing that. But with regard to the registry requirement, Samuel S. says that the defendant must exhaust all administrative remedies. So I know there had been SORB hearings as far as the leveling, but those were when SORB moved to reclassify the defendant as a level 3 sex offender. So she certainly could move to have him brought back to a level 1. And as the court said in Ronald R., the registry requirement is collateral. So it's not part of the criminal case. So there's no right to review other than 211.3. And that would be the, of course, the court's superintendence of powers, where there was no other remedy for him to choose. So that's all I have. As such, the Commonwealth respectfully requests that this honorable court make those dismissal orders. And if it is inclined to decide the merits of this case, that it affirm the orders of the Worcester Juvenile Court. And if there are no other questions, I'll rest on my brief.
Seeing none.
We are now live and recording.
Thank you. Well, welcome to the appeals court. My name is Justice Meade. With me this morning.
We are now live and recording.
Thank you. Welcome to the appeals court. My name is Justice Meade. With me this
We
morning.
are now live and recording.
Does someone have
the attorneys have the
live
volume?
feed on? If someone has a live feed on, please shut it off. What is a live feed on? Please shut the YouTube channel.
So Attorney Mutza or Mr. Mazer, you need to turn off the YouTube channel if you have it on right now. Attorney Mutza or Mr. Mazer, you need to turn off the YouTube channel if you have it on right now. Mr. Mazer, you need to turn off the YouTube channel.
Okay.
All right. We'll see. I have Attorney Matsu muted. All right, Attorney Mazza, have we got it sorted out?
Yes, I think so.
All right, perfect.
Okay.
We are still live and recording.
Take two. Welcome to the Appeals Court. My name is William Meade. With me today are Justices Milkey and Neyman will be the panel on your case. As you see, sometimes we have technical difficulties. If that recurs, and somehow one of you or we get disconnected, we will reestablish that connection and all be deprived of any time to which they are entitled. You'll notice periodically that we seem to be looking to the side. We're looking at our notes that are on a separate computer screen and we are paying attention. Each side gets 15 minutes. We do not entertain rebuttal. We have read everything, so it's my best advice to get right to the point. With that, the next case is 2017 P1451, Patrick Sasso versus Jeffrey Mazer. Mr. Mazer. You need to unmute yourself. Mr. Mazer, you need to unmute yourself.
Can you hear me now?
Yes.
Good afternoon, Your Honors. Jeffrey Mazer, acting pro se in this matter. Just to give you a brief procedural history in this case, this is a matter that's stemming from an underlying fee dispute between myself and Patrick Sasso. The dispute was taken to arbitration with the Mass Bar Association Fee Arbitration Board in April 28th of 2016. The arbitration board ruled in favor of Mr. Sasso. On June 16th of 2016, I filed a complaint in the Essex County Superior Court to essentially appeal the arbitration award. Almost simultaneously, a few days later, the appellees filed a complaint in the Suffolk County Superior Court to enforce the arbitration award. We had a hearing at Suffolk County Superior Court in July of 2016 and had agreed to consolidate the matters in the Suffolk Superior Court. As part of that hearing, it was agreed that the matter in Suffolk Superior Court would be stayed pending the time that they received the file from the Essex County Superior Court. Notwithstanding that issue, apparently the Essex County Superior Court had scheduled some hearings on the matter, and ultimately for both parties' failure to show up to that hearing, the Essex County Superior Court ended up dismissing the matter in the Essex County Superior Court. And then in December, the Essex County Superior Court forwarded that file over to the Suffolk County Superior Court. That was 12/20 of 16. And then 8 days later, a default was issued in the Suffolk County Superior Court alleging that I had failed to answer the complaint. And as I indicated, there was an agreement that everything was stayed. So I essentially filed a motion, the defendants filed a motion for assessment of damages, and I filed motions to basically vacate the dismissal in Essex County, as well as get rid of the default judgment. My motions were denied on February 28th of 2017.
Mr. Mazer, I'm apologize. I'm going to interrupt you because we've read everything in the record appendix and we've read the brief, so this is all known to us.
Okay.
Let me ask you a fundamental question, which is, as I understand it, you were trying to appeal the entry of the default judgment, correct?
That is correct, yes.
Okay. And there was a hearing on that motion, is that correct?
There was a hearing on that motion, correct.
Okay. Was that hearing done, was there a private transcriber used, or was it done via electronic court recording procedures, proceedings that were controlled by the court?
I believe it was done electronically.
So it's electronically. So that puts this under Mass Rule of Appellate Procedure 8B3 then, correct?
I believe so, yes.
Well, that's an important question because the procedures for 8B3 and 8B1 are different. So it would be helpful if we had the answer to that. And it seems your answer is you think so.
I honestly, I don't remember if, I know there was a live reporter at the motion for the appeal, and I just can't recall if there was a live reporter at that February 28th hearing or not. I just don't want to misrepresent to this court. My understanding is it was under 8B1 that we brought all the motions before Judge Ames.
But you're not appealing those motions. You were trying to appeal, as I understand it, the motion for entry of default judgment that was allowed.
That's correct, yes.
So isn't the relevant transcript that you would need, or in this case you decided you did not need, doesn't it pertain to the hearing on that motion?
It does, Your Honor, yes.
Okay.
This case was stayed for many years, and I read the litany of status reports, but I confess I don't know what happened with the bankruptcy issue. What's the status of the bankruptcy?
The defendants were deemed not to essentially be exempted from the bankruptcy claim. So that allowed this to move forward.
And what happened with the client security board?
The defendants have been compensated by the client security board.
Go ahead.
Okay.
Well, let me ask you a question. With respect to the cure letter, if you will, that you submitted to the court on April 24th of 2017, the judge made a finding, I believe, that you did not serve that on counsel for the opposing party. Is that correct?
That's what the judge found, yes.
Assuming that we find that we determined that that was not clearly erroneous, that finding was, does that impact the cure?
I would suggest it doesn't, because what you look at is you look at a snapshot of what happened prior to that June 8th, 2017 hearing. And with respect to that particular document, that document was also attached to my opposition to the motion to basically my opposition to the motion to dismiss the appeal. So my position is that was attached to that motion as attachment C. And that is, I have the site in the appendix, if you can bear with me for just a moment. A123 and A124. Which is attachment C to my opposition to the motion to dismiss the appeal, which was submitted to opposing counsel on that same day, April 24th of 2017. There's no dispute by Attorney Matza that she did not receive that opposition. So my position is that on April 24th or a day or two thereafter, she was in receipt of that document, if nothing else by that attachment. So by the time of the June 8th, 2017 hearing, I had cured that alleged misstep.
Okay, so that's just a copy of the letter, as I understand it, and it shows that it was, all it says is CC Nancy Matza Esquire.
Correct, but if you look back at the opposition itself on the certificate of service, you can see that that was served on April 24th of 2017, and she received the attachment on that date as well, along with the opposition.
Okay.
May I proceed?
Yes.
Okay, so what I want to jump to, is certainly our position is that obviously the judge failed to apply the cure provision. Now the appellee attempts to circumvent the cure provision by alleging that we hadn't in fact cured the provision. We've talked about one of those factors that the appellee raises, but there's two more that the appellee seems to raise. And jumping back to that last one that we talked about in the letter, if you also look at the transcript, Attorney Matza does in fact admit that she did receive the letter. If you look at, if you can bear with me for a moment. On A128 of the transcript, and I'll pull that up on my end as well.
Attorney Munson says she did not receive a copy of the letter. She says she received a call from the court and then she received the letter.
Correct. So she admits she did receive the letter. She claims that she received a call from the court. I don't know in what context. But she does admit at that hearing that she had received the letter prior to that hearing.
Any explanation you want to offer for the lack of service on multiple occasions?
Yes, that's what I'm getting to, Your Honor, is essentially my position is I've served every time, and the defendants are making allegations that I wasn't serving them. And I have some responses to that. As you can see in the transcript, with respect to the notice of appeal, for example, I had put in the certificate of service that I had served it by email, and I inadvertently, because I was doing a copy and paste, had indicated that I had served it in hand, which was actually, and I admitted to the judge that that was a mistake, that I had in fact sent it by first class mail and by email. I had offered Judge Ames, I had a copy of that email correspondence showing that I at least sent it by email, and Judge Ames wouldn't accept that document. And that's referenced in the appendix at A129 through 130.
Because you failed to follow Superior Court Rule 9A, right?
No, she was claiming that I had never sent a copy. Attorney Matza was claiming I never served her with a copy of the notice of appeal.
Yeah, well, you have to, under the rule, you have to serve opposing party and wait for their opposition or for the time to expire before you can file a motion.
Correct. But what I'm talking about is the notice of appeal, that Attorney Matza had claimed that she had never been served a copy of the notice of appeal. And so what I'm trying to indicate is that unfortunately, I couldn't prove that I had mailed it, but I had offered to provide Judge Ames with a copy of at least the email that I had sent to opposing counsel with a copy of that notice of appeal.
Isn't that part of the problem here? It's that Judge Ames, there was evidence, or at least information, I should say, provided that you, throughout the earlier course of the proceedings, had failed to provide service or correct service on any number of occasions. So then confronted with these issues regarding the notice of appeal and the cure and all of the other requirements under Rule 8, when Judge Ames asked you to prove service in these instances, you were unable to do so. And so it's almost as if she drew an adverse inference against you when you were unable to prove service in light of the prior history in the case. Do I have that correct?
Correct, Your Honor. And what I would suggest is that is certainly applicable when you deal with excusable neglect. But with respect to the cure provision, which my contention is should have been applied in this situation, I had met all the procedural prerequisites to cure that prior to that hearing.
So that begs this question. Judge Ames dismissed this on the basis of failing to cure, but she further based her dismissal of the appeal on failure to comply with Rule 8, failure to take steps to, let's say, advance the appeal, failure to provide notice on myriad occasions, both throughout the appeal period and prior to the appeal period. So let's assume we agree with you on the 10C issue.
Mm-hmm.
What about the Rule 8 and Rule 9 violations that Judge Ames also made determinations of fact about?
Well, I would suggest that all of that goes to the excusable neglect realm. And I would suggest that...
Let me clarify my question. So the first part of the question is, it seems to me you are agreeing with me that there were Rule 8 violations and Rule 9 violations by you, apart from the 10C violation, correct?
And what you're referring to is the alleged failure of service of process?
Yes. Failure to serve, failure to provide notice at various stages throughout after you filed the notice of appeal, including the filing of the notice of appeal.
The only one that I agree is that the letter with respect to the transcript should have been filed with the court on April 10th, and it wasn't filed with the court until April 14th. I dispute the allegations that there wasn't service on the defendant with respect to the appellate procedures.
But your burden is to show that the judge's findings in that regard are clearly erroneous. So assume for the sake of argument, we agree with the judge, or we don't find them to be clearly erroneous. Again, apart from the 10C finding.
Yes.
Are you with me? Assume we find that. Help us with our analysis at that point. Why are those other shortcomings not sufficient to warrant dismissal of the appeal? And what authority do you have for the proposition?
Sure. The Neuwirth case, which talks about 10C, and essentially talks about the fact that once the cure provision is met, you never get to the issue of inexcusable neglect. In fact, it talks about 10C contemplates there will be situations where an appellant who has committed inexcusable neglect nevertheless can escape dismissal by taking advantage of the cure provision. So my contention is entirely that I met all the provisions. I cured the alleged missteps prior to that June 8th, 2017 hearing, and that the judge erred by failing to accept that cure provision and went exclusively to inexcusable neglect.
Well, your time is up, but if our panel chief will permit, I have an additional question.
Go right ahead.
Thank you. Neuwirth goes on, however, to say that even where there is a 10C violation is properly cured, dismissal may still be an appropriate sanction based upon other factors. And that, and those factors include failure to properly pursue the appeal, notice violations, violations of other rules, such as what Judge Ames found here. So why should we overrule the judge's determination here?
Well, again, my contention is that I attempted to demonstrate to Judge Ames that I had in fact met those requirements, number one. And number two, I think if you look at the failure to send the notice of the transcript request, for example, that in fact, it was a matter of 2 weeks. It wasn't something that was months and months of delay. Neuwirth talks about that and makes the distinction between years of delay versus months of delay. And again, by June 8th of 2017, everything was cured.
Thank you.
Thank you, Your Honor.
Ms. Mazza.
Morning, Your Honors. May it please the court. If I'm not speaking loud enough, let me know, please. Your Honor, Justice Simon, it was an 8-3. As I reviewed the records, one of the issues from Judge Ames was that it was 8-3.
I thought that the judge found that 8B1 was violated here, and that's what you alleged.
Well, she also has 8B3.
Okay.
That's the things that she missed, that she responded to. While my appellant is acting pro se at this point, it is a known factor that the appellant was a practicing attorney until he was disbarred. And one of the reasons he was disbarred was this matter, the underlying matter. But be that as it may, he has a lot more experience in following 9A, following 10B, 3C, whichever. He knows the rules and regulations, or should know the rules and regulations. And his being 2 weeks late or 3 weeks late or failing to notice is, I think, more unexcusable than if it were a truly pure pro se client, as Neuwirth was. And
so let's start with this question. Do you agree with your brother that he made a timely cure with the filing of the letter on April 24th, 2017?
No, I do not.
What's your basis for disagreeing?
My basis for disagreeing is one, he in court stated before the judge, before I opposed it, that he physically hand-delivered this opposition, his records to us. They were never physically delivered, hand-delivered. He has a history, in this case alone, of failure to notice. If we go back to his original opposition to the underlying matter, and that was dismissed by the Essex court. I drove over to Essex and said, what is this matter? Because I had no idea. I was not listed. There was no notice of anything to anyone. They didn't even know who I was. The case was dismissed for his failure to appear, his failure to do.
Right, but we're focused right now on the 10C cure issue.
Okay. It's 10C, as far as I can see. I have a notice of appeal from the Superior Court that on 3/30 he filed a notice of appeal. There is no transcript. He had so many days under 9.
Right, the 10C cure provision provides that if he essentially cures the issue prior to the hearing on the motion to dismiss, then that is sufficient. And here he filed the letter with the court on April 24th, which was prior to the hearing.
I do not believe that the judge accepted that as evidence that he had cured, because you read what the judge had said as her result.
Why is the judge not incorrect there?
Because of the history of this case. And
Well, I understand what you're saying, but that doesn't speak to a 10C cure. That speaks to Rule 8 and Rule 9 violations. It doesn't speak to 10C.
Well, I believe that in the 10C, he was to cure all of the defects prior to the hearing in July, and he did not. He didn't provide the transcript. He didn't order it. He was late. The appeals court said he was late. I had been in touch with the appeals court. So he did not cure all of the issues. He may have cured one, but he did not cure all.
Were the other allegations of non-compliance with the rules set forth as a basis for the motion to dismiss the appeal?
I believe so, yes. Yes, they were. And again, it's historical. His answer to the original underlying complaint was almost a year late in being received by the court.
So the timeline here is that on March 30th of 2017, the notice of appeal was filed. On May 2nd, 2017, you moved to dismiss.
Yes.
So that is 33 days. Is there any published case where an appeal has been dismissed on such a short timeline? And I want you to assume for purposes of this question that the transcript issue was cured with the April 24th letter.
The only cases that I found that were relevant to this, and I didn't look for that specific issue, was the Hawkins versus Hawkins matter, which is 397-401. Okay, and of course, Neuwirth, where Neuwirth acted as a pro se, even though he did have attorneys at some point, but he immediately cured the matter. And and this was not immediate. I think it was 3 weeks later, and he had a 2-week deadline, or he said he was going to have it done in 2 weeks, but it took him 3. He never asked or filed a motion for enlargement of time. So there are steps along the way to have things extended, such as a motion for an extension of time or an enlargement of time.
What was, if you recall, what was the time between the filing of the notice of appeal and the motion to dismiss in the Hawkins case?
Just a moment. I have the case. I just don't know if I can answer your question.
Well, if you're going to get it just by reading the case, if you don't have it off the top of your head, we can read it. I don't want you to use your time for that.
It is 397 Mass 401.
Yes. Thank you.
Oh, she was blaming the staff at the various courthouses for not providing things in a timely way. And I don't have an answer to your question, I'm sorry. So, as I said, if you read Judge Ames, and I do need to tell you that Judge Ames took a recess during that hearing. And she went back and reviewed the appellate court rules, her availability, I'm sorry, her ability as the Superior Court judge to rule on this, and all of the matters from the underlying matter. And I believe you read her response. After having taken a recess and going over every rule that she felt was applicable in the matter.
Counsel, could you address just the larger point that there are a lot of cases, and frankly, Neuwirth is one of them, that make the point that a dismissal of an appeal is a very extreme sanction, and therefore it really only should be used where the conduct in terms of the length of delays and so forth are fairly extreme. How is that satisfied here? One can understand why you and the judge was terribly annoyed by the repeated conduct, but that is a separate question from whether or not this merits the sanction, the extreme sanction.
I think the judge's response as to her rationale behind it is important to see. I mean, she was very clear as to why she was denying it on her opinion historically of the underlying matter. And every instance where he has done nothing and her words were obfuscate the matter. I mean, the underlying matter was to confirm an arbitration award. It's a pretty simple matter. And from the get-go, it has just been delayed by the action of the appellant, specifically by his action, by the 9A, constant 9A failures. She feels that justice was not served for the appellee based on his continuing action. He had said that he had hurt himself or his ankle. And yet when we asked for documentation from a medical provider or whatever, or the ability to use a telephone to contact the appeals court, there was never any response. There was never any proof. There was never any validation. I'm not denying he hurt his ankle. I'm not denying any of it, except that when asked to justify his being licked, he could never do that. He could never justify why he didn't serve me on the original response in Essex. I think her comments about his reasoning for doing all of this, but that she felt that he did not have, as Neuwirth did, ignorance of what he was doing, and then when he found out about it, absolutely rushed to take care of and cure. And the judge, I think, has historically seen a person who is experienced in the law doing not as much as Neuwirth even did. I think she took her responsibilities as a Superior Court judge seriously in this matter.
Attorney Mutza, I have two more quick questions for you. One is, at page 5 of your brief, you state, in her memorandum accompanying her decision on the plaintiff's motion to dismiss, the judge cited X, Y, and Z. I don't see an accompanying memorandum.
Oh, I'm sorry, Your Honor. It's on the side of her decision. Wait,
You just mean the margin entry?
I'm sorry.
So her findings are located in the transcript, not in a separate memorandum. Is that correct?
Yes.
Okay. The only other question I have for you is, you said that the 10C letter, you say it's insufficient because it did not cure the multiple violations. What other violations are you talking about when you say that? Yeah. Because Rule 10 applies to the transcripts.
I did not receive those transcripts. I have a date here A letter from the.
Mr. Mazer put in his letter that he was not seeking any transcripts.
I'm looking at a letter from the judge on March 31st, which should be in the transcript, that there was no transcript, and he either has to say he didn't tell the court he didn't want one. And you're
Understood, but the cure is when he says, I've decided prior to the hearing on the motion to dismiss, the cure is his representation that no transcripts will be needed for the appeal. So my understanding is that is an appropriate 10C cure. You're saying it didn't cure everything. What other violations did that not cure?
Again, his failure to serve, his failure to notify the court. He never notified the court as well. The appeals court was not notified because I did speak with the clerk. Her name is, I can't remember her name, I'm sorry. I spoke.
So would it be fair to characterize your answer then as, although 10C may have been cured, he did not cure the additional Rule 8 and Rule 9 violations? Is that better articulated?
Thank you. Yes, it is.
Okay. Thank you.
I'm going to rest on my brief the rest of it. I have no other, unless you gentlemen have other further questions.
No, I don't, not seeing none. Thank you very much. We'll
Thank you
take
both.
this under advisement.
Thank you.
Your Honors, thank you. May it please the court, Karen Young on behalf of Father in this care and protection appeal. The only issue that Father challenges is the trial court's decision regarding the adoption plan for his daughter, the child. The department obtained temporary custody of the child soon after her birth. She was born substance exposed due to mother's use of Suboxone and required treatment for neonatal substance disorder. Mother and father participated in caring for her during her hospital admission, and medical staff involved in her care discovered that the child suffered from a skull fracture. They suspected that the injury was caused from a fall. Each parent was questioned regarding the source of the injury since they had been staying in the child's room while caring for her. Mother and father denied dropping the child or injuring her in any way, and there was no direct evidence that father was negligent with respect to this injury.
Father stipulated unfitness, yes?
Yes, Your Honor, I'm just providing a little bit of the back.
Yeah, we've read everything, so let's get right to your argument.
Okay, so at the February 21st colloquy with the judge, father indicated that he was unable to care for the child and he believed that a family member would be the best adoptive resource. He indicated that he had contacted his sister and that she was willing and interested. The judge accepted father's stipulation, delayed issuing the decree on the termination, awaiting the expedited ICPC, the Interstate Compact on the Placement of Children, on the aunt to return since the aunt resided in Maryland. So the court acknowledged at that time that since the ICPC was required, the trial would have to be continued for several months. However, a few months later, on June 25th, prior to that, the department filed a motion to continue the trial to October, which the judge denied on July 12th. I'm sorry, the department filed the motion, the assented to motion to continue, the joint motion to continue on June 25th. At the next hearing on July 25th, father's counsel renewed the motion to continue the trial. And again, the judge denied the motion.
So my understanding is that your argument is that the judge abused his discretion by denying the motion to continue because father needed the ICPC approval. Is that correct?
That's correct, Your Honor. And
so my follow-up to that is, in order to obtain relief here, I think you need to show prejudice. So where is the prejudice when the judge assumed for purposes of the trial that the ICPC would have been approved or would have approved that which was being sought?
Well, Your Honor, I'm arguing that the whole circumstances evince abuse of discretion, the statements that the judges made, the act of refusing to continue the case in spite of an assented to motion, the department assented to continuing the case, the statements he made at the hearing. This wasn't a case where the parties just weren't ready, as in that weren't prepared.
Didn't the judge did continue it a couple times, right?
Yes, Your Honor, but
and Maryland had still done nothing to initiate the process.
That's true, Your Honor. But again, this was at no fault of father or his adoptive resource, the aunt. The DCS motion simply requested a couple of months continued to October. Pardon me.
Did Maryland ever do the ICPC?
At this point, it doesn't appear as though it was concluded. It appears as though it was stopped following the judge's decision on September 12th. But Your Honor, I'm just arguing that back to the denial on the motion to continue, the judge's statements at trial indicated he just wanted to get this done. I understand there's the expediency of pushing cases forward and the judge is beholden to do that. But the statements that he made, he had another ongoing trial with an expert on the stand who started that morning. If he decided in favor of the aunt, he'd simply issue an order to await the ICPC and make a final decision then.
So why, counsel, why wasn't the judge effectively saying, I'm not going to wait for this because even if she wins approval in Maryland, it's not going to make a difference to my determination of which adoption plan to choose?
Well, Your Honor, I understand that the standard of review here, the abuse of discretion, is quite deferential to the trial judge, but I'm just arguing father was prejudiced by the judge's greater concern and a glitch in the ICPC, that his docket was heavy. I'm suggesting that it was an unreasonable weighing of the factors and that essentially this prejudiced father and showed that the judge had already made a decision, that essentially he said, look, if I decide in favor of the aunt, I'll simply issue an order to await the ICPC and make a final decision at that time. So I'm just suggesting, Your Honor, that the departure from the established procedure of awaiting the results of the ICPC, indicating that it wasn't really necessary, his remarks that if I find for the aunt, I'll go back, I'll delay things, I'll await it then, all suggest that he'd already made his decision about the competing plans. During father's colloquy back in February, when he voluntarily surrendered his rights, he simply asked the judge to give placement with his sister a fair shake. And I'm just suggesting, Your Honor, that his action in denying a short continuance that the department assented to suggests that he'd already made a decision. And for these reasons, I ask that you reverse the decision.
Okay.
Thank you.
Thank you.
Attorney Farmer, you're going first?
I don't believe so.
Okay. Attorney Sullivan?
Yes, it's Lashup Sullivan, Your Honor.
Okay.
Thank you. Matthew Lashup Sullivan for the department. So my sister pointed out that, the father asked simply that the judge give his proposed placement a fair shake. And that is exactly what the trial court did here. The trial court evaluated all the evidence. It heard witness testimony from each of the members of the pre-adoptive family, which is the foster family that the department had proposed be the adoptive resource. That is the pre-adoptive mother, the pre-adoptive father, and the pre-adoptive brother. And the trial judge also heard testimony from the aunt. And the trial judge in his findings said that the aunt's testimony on almost all points was credible. And the trial judge didn't determine that the placement with the aunt was unsuitable in any way. It was simply a determination of, okay, both of these adoption plans pass muster, both of them are suitable, but we still need to determine which one is in the best interest of the child. And the trial judge weighed that evidence of the significant bonds with the foster family, connections with the extended family and community, and the pre-existing bond with mother that the trial judge found would be in the child's best interest to continue visitation, and the ease of facilitating that with a Massachusetts placement versus Maryland, and found that that outweighed the biological relationship with the aunt, where there was effectively no family relationship other than in a biological sense, as the judge found, because the child and the aunt had never met, and because the aunt didn't even have a close relationship with father, and that's in the findings. So as far as the notion of proceeding with the trial, this court in adoption of Jillian affirmed a similar denial of a continuance for essentially the same reasons, because the length of time that had passed without resolving the matter as to the child really tends to undermine the legislative policy for speedy resolution of child custody matters. So in adoption of Jillian, this court affirmed a trial judge's denial of a motion to continue for that reason, and the judge cited the same reasons in this case, and it should be affirmed for the same reason. As far as the trial judge's statements at trial are concerned, my sister relies on adoption of Tia in her brief, but really the statements that were problematic in adoption of Tia versus the statements that the judge made in this case, it's basically night and day. In adoption of Tia, the trial judge there had, before hearing from the witnesses, had urged the mother, you should settle this case. You don't want to decide this case, effectively saying you're not going to be happy with my decision, and was urging settlement. In this case, the father's counsel and the father have not pointed to any statements like that by the judge not in terms of, we need to proceed with the trial, but in terms of, I'm favoring this placement versus that placement. The only thing that happened here is that after granting a continuance for the ICPC, then upon a motion for an additional continuance where it was not at all clear that even after that additional continuance, the ICPC would be done at that point, leading to a cascade of more and more continuances, because there was no clarity on when the ICPC would actually be finished. The trial court assumed, based on the testimony, that the ICPC would come out in the father's favor. So the only issue that kind of was assumed rather than hearing all the facts was the ICPC itself, and that was resolved in favor of father. And now father is objecting to that issue being resolved in his own favor. And so because of all the various factors the trial court cited in terms of the relationships and in terms of the lack of a relationship with the aunt, and the fact that the judge assumed that the ICPC would be coming out in father's favor, which is something that actually this court has affirmed several times where ICPCs are still pending. So in adoption of Davis and adoption of Eric, these are two cases where the trial judge did the same thing as it did in this case. And adoption of Eric, I think, is a good example where all parties agreed that the out-of-state placement was fit, and the trial judge proceeded with the trial where the ICPC home study was, as it said, essentially a formality because no party doubted the relative fitness. So that's not to say that, according to adoption of Warren, and it's true that in order to actually order custody, the ICPC has to be complete, but that doesn't mean that the trial judge can't hear the evidence and determine what's in the child's best interest, and adoption of Eric and adoption of Davis both stand for that. So if the panel has no other questions, I'm happy to turn it over to the child's counsel.
Seeing none, Attorney Farmer.
Thank you, Your Honor. This case was in a study in the interplay between the ICPC and the ultimate best interest of the child's determination. Because all you have in the ICPC is a process whereby an agency in another state looks at a home, determines if it is suitable for the child in question, and then that agency has to write a letter to Massachusetts or whatever the sending state is, saying that the proposed placement does not appear contrary to the interest of the child. No determination or suggestion that this is in the best interest of the child. It just appears that it's not going to be contrary to the interest of the child. In other words, it's a possibility for the agency to determine that this household, and then all it does is write a letter. So, with regard to how that plays out with the best interest, it doesn't necessarily come into evidence. It doesn't have to come into evidence, other than saying that it has been approved as a process. It's just not part of that best interest investigation. So what we have here, as it started out with, is a question of where is the prejudice to the father? There's no indication that there is any prejudice to the father. The judge, in fact, started this whole inquiry, so to speak, when discussing the stipulations of both parties and understood the father had a competing claim. The judge offered, as he should have, that he would not enter a final dispute because he was going to allow the father the standing to present his claim. So we have this best interest determination starting with the judges recognizing the father's desire to present his plan and following through. Then when it comes to both the motion hearing and then ultimately in the decision making, counsel agreed that Maryland was likely going to make a suitability determination. The judge recognized that the evidence that the aunt presented certainly reflected that the household was a single household who experienced raising children. The actual letter from the agency in Maryland was not necessary in going forward with the decision making on what is in the best interest of the child. The child had deeply bonded with the pre-adopted family. He was embraced by the extended family. The family was able to show that their household was suitable. So best interest inquiry was fully explored at the trial and was not hampered by the lack of ICPC. Now, the law cited by the father wasn't really relevant on this question because the law cited by the father pertains to the child being put in Massachusetts. We're talking about the child going from Massachusetts to Maryland. It was assumed, the judge assumed that it would be a positive result. The judge took that into consideration in his analysis. The judge was entitled in his discretion to determine that the pre-adopted placement would be in the best interest of the child. And I would suggest that that is exactly how the judge should have held. And so for that reason, I would suggest that this plan be ordered by the appeals court and
We lost your audio there at the end.
oh, I'm sorry. Yeah, just that the decision of the trial court be affirmed and that the plan for adoption with the adopted family go forward.
Okay. Thank you all. We will.
All right, we are now live and recording.
Thank you. Welcome to the appeals court. I am Justice Meade. With me this morning are Justices Milkey and Neyman will be the panel for this case. We've read your briefs. Each side gets 15 minutes. We do not entertain rebuttal. If we should run into a technical difficulty and we lose connection, we'll reestablish connection as fast as possible, and no one's time will be diminished. Sometimes you'll see us looking off to the side. It's because our notes are on a different computer screen. So we have not lost interest in what you're saying to us. So, with that, I'll call I'm sorry. And this case is impounded or partially impounded. So please, no names, just use initials, please, or other pronouns. So the next case is 2019 P 1797 LC versus AW. AW, you go first. You get 15 minutes.
Hi, everyone. I don't feel as though that the restraining order applied against me was justly applied for reason, first of all, jurisdiction, secondly, sufficiency of evidence, and later to be discovered that the disciplinary reports on conduct that is 22 hours anterograde from the time the report was apparently generated. So that is, an anomaly. You cannot report on conduct that is said to have happened in the future, which is a glaring red flag, in my opinion, of the veracity of the claim overall.
Could we try to unpack this a little bit? There are, strictly speaking, three different orders here. There was the initial ex parte order. There was the essentially continuation of that while the case was being moved. And then there was the third order, the 1-year order issued by the judge in Worcester. You appear to be trying to challenge all three. Why isn't the ex parte order superseded by the second order, the order that arose out of the hearing in which you attended personally?
Okay, I feel, sir, that that the ex parte order was applied erroneously outside of jurisdiction, and that Judge Sargent, I believe, excuse me if I'm mixing up the judges, Judge Sargent applied the restraining order without exhausting the sufficiency of the evidence. LC produced, if she did in fact produce documents, those documents were then said to not be able to have been read by the court. If the court cannot read the allegedly harassing material, then there is not grounds to supply or enact the order against me. If they're saying, okay, well, I have these alleged threats are contained in this document, and there is nothing on that document that can be read, the sufficiency of the evidence is not, that has not been completed.
In LC's brief, counsel brings note to the fact that our case law says that once the 1-year order is issued, it supersedes the ex parte order, and it's not properly before us on appeal.
Well, I mean, that gets into a whole other section of, I would think that LC's appeal, plaintiff's appeal, or brief, excuse me, should be discarded for references to material that are outside of the record. That's my first, inclination to that. And my second,
those are open motions before us that the panel will decide. But,
okay.
But my question is, the case law says that the ex parte order is superseded by the 1-year order. So I didn't want you to spend too much time about the ex parte order because it's not properly before us.
Well, okay, sir. So once the case was transferred, the case was transferred, but not the order. LC did not present to the Worcester District Court to present a complaint in that court and start the initial process there.
So just so I understand you.
I'm sorry.
You seem to agree, since you're the one who raised the issue, that the Worcester District Court had venue over this matter. And yet you continue to raise venue as a challenge. As best as I understand your argument, you seem to be saying the case couldn't be transferred to Worcester. She would have had to refile it as a new original case. Is that what you're arguing?
Well, that's the way, yes, sir. And that's kind of the way that I understand it as I look at the guidelines for the abuse prevention hearings. And I'm the first to admit I'm not an attorney, I'm a pro se defendant. And it's stated that if, and really sorry that I'm not going to be able to cite chapter and verse on these things. But speaking generally, in the guidelines, it states that that the predetermination of jurisdiction is to be made, and that once the jurisdiction is then made, that the complaint needs to, this again, not chapter and verse with strictly the guidelines, but then case law supports that the complaint must be filed, heard, and determined in the court which has jurisdiction. So
do you understand that jurisdiction and venue are two quite different concepts?
I don't necessarily understand that. They seem quite similar to me. However, I do appreciate the fact that a venue is like, Worcester versus, was it not Dudley? Clinton. Yep. Excuse me. Sorry. But I mean, I feel like so if it's like a Venn diagram, I feel like there's some equal ground, that equal footing on the two concepts, while I do recognize them to be separate. The second portion of that would be that so if she didn't file the complaint over there, the three elements filed, heard, and determined were not met. Secondly, the transcript picks up where the transcript of the second hearing, once it was transferred, let me back up. So an action, Judge Power then acted on the order, transferred the order to the Worcester District Court. The Worcester District Court picks up after the clerk says, hey, everyone saw the evidence, which may or may not be true. I didn't say that I saw any evidence. And Judge Power, I believe, gives her the evidence back before the conclusion of the hearing. There is no evidence recorded on the docket in the docket entry sheet in the transfer from Worcester, Clinton to Worcester, because it gets confusing very quickly. From Clinton to Worcester, nor was there any evidence docket. The clerk spoke about what was going to be entered onto the docket entry sheet, and it never was. So there was no evidence there. So
those strike me as two different issues. I mean, there's no question that the record keeping of the district courts may leave something to be desired, but that's a separate issue, whether or not there was evidence produced and admitted. And the transcript, for example, of the third hearing begins, I believe, with her attorney stating that, oh, here are the documents and I've shown them to you. And in terms of the documents we now have, as I understand it, they're in three parts. There's the incident report, and that has an exhibit sticker right on the front of it. Two, there are the messages. I can't remember if it's Facebook or something else, but a series of messages. And those were the ones that the court's copy was hard to read. And then three, there's your criminal history report. And those are the only three categories of documents we're talking about. In terms of the illegible messages back and forth, that, as best as I can discern, that appears to be a product of the fact that the court said, okay, I'm going to give you your originals back. I'm going to have the clerk make a copy first so that the copies are illegible. Now, and frankly, if those copies were included in a record appendix for us, we would have the clerk's office send back and say, these can't be read. Send us the legible versions. So I'm not seeing how her attorney did anything wrong in bringing that to our attention.
Well, sir, I would say that the exhibit sticker, the Clinton District Court decided to mark an exhibit sticker on exhibits that could not be read. LC was in accompaniment of a Worcester County Sheriff's Office party of some repute. At the time, it was no reason to believe that it was, the attorney. The exhibit sticker is, so the judge says that we are going to mark these documents here, and they have a back and forth in two separate spots, that we're going to mark these hard to read documents that are unable to be read as exhibit number 1. And as you adroitly pointed out, that the disciplinary report or incident report, or however you want to label that particular report, with the incident sticker, the exhibit sticker on it, has a docket number originating from the Clinton District Court. So it's not like something that the Worcester court supplied. He is trying to say, or the argument is, that despite the record showing that the only thing that was submitted was 3 pages or 2 pages of documents that could not be read, here is this incident report, which LC said did not exist in her affidavit. And here it is with an exhibit sticker on it. It's not memorialized in the record. And that exhibit sticker has a docket number originating from the Clinton District Court. Fast forward to the woefully inadequate record keeping of the 2 courts. That's where the hearing picks up, and the clerk, not the lawyer, says, all right, he's had a chance to look at this stuff. All right, and let's proceed. And at that point, where it gets muddy is that the second order is a continuation of the first order, of the first ex parte hearing, of the ex parte order that was issued.
And the order was continued with your affirmative consent. You said, if it gets transferred to Worcester, you were not going to oppose the order staying in place until the Worcester hearing.
Well, so at that point, sir, I was also under the misunderstanding, because I'm talking to the judge at that point, and the judge also told me that she had the right to file it and, here, and this was before any knowledge I had of the rules of the guidelines of abuse prevention hearings. Me saying that to the judge was because he had mentioned that, oh, well, you don't want to be in trouble for having her address. It's like, well, no, not only do I not want to be in trouble for having her address, as if that were a thing, I'm trying to clearly show you that you were supposed to have found the jurisdiction. You did not find the jurisdiction, and so forth. So when I say that, when I said that, what I was saying when I said that to the judge was like, you guys are going to do whatever you're going to do, and I'm not balking any of it. I will continue the same thing, the same argument in another court. You want to do it there? Sure. And I assumed that what was going to happen when he told me, well, the statute states that, if she fled a place or went to a place, and I have the authority to transfer it. Well, I later found out, reviewing the guidelines, that that's not necessarily the case, and that if he transferred the order, that's an action on the order that he did not have the authority, according to the guidelines, to do. That was an action that he did not have the authority to do, because that's an action on the order. First, he implemented the order, and then he acted on the order by moving it. So that's I when I said that, yep, because he told me flat out, well, I'm going to transfer it. It's not like I was going to stand up and balk and, raise a stink, it was going to get transferred whether I did or I didn't. So I went along with it. I had already raised the stink, by the way. I'd already said, well, here's the thing. Well, all right, well, I'm gonna transfer it. Oh, okay.
You have about 40 seconds left, so why don't you sum up?
Oh, well, and the in conclusion, I feel like, LC had stated that insufficient grounds in the testimony that the judge heard in the second hearing, the judge had heard even less. And in the final hearing, LC, the third hearing that has no transcript or has nothing, evidence before us, in that hearing, she stated that she brought documents that were clearly printed, dated later to the first hearing. So that's where we get this confusion about what the record contains. Sorry.
Okay. Thank you.
Thank you.
Mr. Abdallah.
Good morning, Justices, and may it please the court. My name is Andrew Abdallah, and I represent LC in this matter. The decision of the district court should be affirmed because there was sufficient evidence that AW engaged in more than 3 acts of true threats directed towards LC. These were true threats not in the sense that they threatened physical violence. They were threatening in the sense that they were made in a setting which rendered them inappropriate and inherently threatening. First, there was evidence that AW propositioned LC in the correctional facility while they were inmate and officer on April 15th, 2019. Next, there was evidence that after being released, AW sent.
Can I stop you there? The incident report that the defendant is contesting isn't frankly all that dramatic by itself. It doesn't say that he propositioned her as such. It does suggest that he may have, if you will, come on to her. But I just want to make sure we don't exaggerate the evidence here. What's the evidence that he actually propositioned her?
Justice, it can be found in 3 places. First, just briefly in her affidavit that he harassed her in an intimate manner on April 15th while in her custody. Second, in the incident report, as Justice has just referenced to. Third, it can be found in the record in AW's affidavit that he filed with the Worcester District Court. It's at the record appendix 67 through 68, and he describes this interaction over a series of a day. And I think to the court's point, which is really what this case is about, this is not a propositioning that is sexually explicit in nature that out in free society we would consider a true threat. And I'd ask the court to look to the case law in Commonwealth v. Chu, where the Supreme District Court recognized speech in the confines of a correctional facility is different. And words or statements which out in free society would not be inherently threatening can become so in their context. So I think to the court's point, no, this is not an instance where there's an aggressive encounter or anything like that. This is an instance where, based on both parties' statements, AW does proposition LC, and I won't inflate it any further than that, Justice.
Yeah, I mean, well, okay. Well,
next, after being released, and again, we look at the course of conduct, not one individual act. After being released, AW sends a series of Facebook messages to LC and then creates fictitious responses from LC back to AW, creating the appearance that there is some level of romantic relationship between the parties. Again, these statements, Justices, made out in free society may not be considered in an isolated instance to be inherently threatening, but it asks the court to focus on the nature of the relationship of the parties. It is such that LC had legal custody of AW in a correctional.
No, but just to be precise, that was before these statements were made, correct? The actual Facebook messages were after he was released.
Yes, Justice, but I don't think that makes them any less inherently threatening. I don't think for a female correctional officer to have a released inmate start sending romantic Facebook messages and create responses from her voice makes it any less fear imposing. I also think there's evidence in the record from both parties, testimony-wise, that this happened. I think AW frankly testified that he did send these messages and that the responses did not come from LC. Next, there was the criminal and civil history of AW, which we have record support that the district court did review and that AW testified to. From the propositioning in the jail to the multiple separate comments and responses on Facebook, there were more than 3 acts that were inherently threatening. And there was evidence that they did in fact cause fear. As LC testified, they caused her to be escorted to and from her work each day.
Now, could you address the issues regarding the record and whether or not the documents collectively known as Exhibit 1 are accurate documents that were before, especially the third judge or the judge who held the third hearing?
Certainly, Justice. There is record support that they were marked and admitted in the Clinton District Court in the ex parte hearing. And then if we look at the docket sheet on 53, they are transferred to the Worcester District Court. There is also record support.
No, they're not.
AW,
Oh, sorry.
Speak uninterrupted.
I'm sorry.
You should be muted. Go ahead, Attorney Abdullah.
Certainly, Justice. I'm sorry. Thereafter, as I think Justice Milkey pointed out, at the beginning of the hearing.
We should hang on. We need to get AW back.
Certainly.
All right, I'm not sure where he went. Hold on, I'm going to pause the recording. All right, we are now live and recording once again.
Thank you, Justices. If I may proceed, I believe I was at where the record in the Worcester District Court hearing, the third hearing, evidences that this material was reviewed by the district court. There are questions directed by the district court judge about the Facebook messages. AW himself testifies in the transcript at page 85, referencing the Facebook messages, saying, I don't see any direct threats in these messages. And I think to the heart of the court's question, I obtained the exhibit originally from the Clinton District Court. I contacted them during the pandemic and told them I was appellate counsel and needed whatever exhibit had been marked. They emailed me that 5-page exhibit. I then contacted the Worcester District Court, asked the same question, and I was told that that 5-page exhibit was in the Worcester District Court file, and it was once again sent to me via email in a poor condition.
In a perfect world, a dispute over whether documents were in the trial court record would be resolved in the trial court, correct?
Yes, Justice.
Is there anything else you'd like to tell us?
There is not, Justices, and if there are no further questions, I will rest on my brief on the other items.
Okay, thank you very much. Thank you both. We'll
Thank
take
you,
this under
Justice.
advisement.
Thank you.